warahmatullahi wabarakatuh. My name is Hafiz Iskandar bin Ismail. So me and my teammates are going to present an assignment of law of tort entitled Defamation. Defamation may constitute the defamation whereby it is wrongly done by words. Defamation is one that tends to lower the plaintiff in the mind of the right thinker. There are technical differences in the defamation law between the libel and slander. Libel refers to permanent forms such as print, and defamation to temporary forms such as speech. The complaint statement must be communicated to others the plaintiff. However, the core is that the statement must be defamatory as stated above. If it has this special quality, it is not necessary for the plaintiff to prove hatred so that it falls on an effective defendant. For example, to claim that a person is a criminal or immoral behavior is defamatory. To add, the statement must be false, and this is resolved in court by the defendant applying for justification. The Defamation Act of 1952 makes it unnecessary for the defendant to show that every charge is true, if those who lie does not endanger the reputation of the plaintiff. Communication has been set up in many ways, including movies and sculpture or via the internet. It is open to the plaintiff to punish the statement, that is, to show that a statement that is not firstly defamation as means of defamation. The plaintiff must state with the word in his application what he means. Statement in foreign language or always require injection. Practical importance is another defense. There is absolute privilege protect certain communication which is protect parliamentary proceeding, judicial proceeding, and official communication. There are two types of defamation. The first type of defamation is libel. Libel is defamation in a permanent form and is usually visible to the eye, such as items in writing which include email, picture, and SMS. The aim of publication of this form will bring the target into suffer, and it will affect his or her reputation permanently, because the defamation is visible to the eye and it will be shared and spread. The defamation must be published and it was claimed to be true. If there was no publication, it was not being considered as defamation. According to the Section 3 of the Defamation Act 1952, it was stated that the broadcasting of words by means of radio communication shall be treated as publication in a permanent form and therefore constitute a libel. Libel is actionable per se. The second type of defamation is slander. Slander is defamation in a temporary or transient form, such as verbal statement. When someone spoken the wrong fact to someone about another person, it was considered as publication to this type of defamation. If the defamation was spoken in the television or on the radio, it was not categorized as slander, but it was categorized as libel defamation. In this scope, online defamation was categorized as libel defamation. It is because online defamation is visible to the eye and it was broadcasted to the internet, and which is accessible to everyone in all over the world. Okay. There are elements that need to be fulfilled to distribute defamation is the word defamatory. The words refer to the plaintiff and the word has been published. As a rule, this requirement is satisfied when the words tend to lower the estimation of the plaintiff in the mind of right-thinking members of society, so that the plaintiff is avoided, shunned, or ridiculed. The court only looks to the tendency of the response or reaction of the reasonable man to the words. The court does not concern itself with whether members of society would in fact avoid the plaintiff, as the crucial factor is whether the word can convey a defamatory meaning of and be concerning the plaintiff. The plaintiff must know what has been said of him and cannot merely guess. In a defamation suit, the intention of the publisher or maker of the statement is irrelevant. The words will be examined objectively that it is effect on a reasonable and ordinary reader or person who hears the word. Words can be defamed in one of three ways: in the natural and ordinary meaning. The words complained of are defamatory in nature or reason if they deny that the plaintiff is an offence or uncertain on motive or lack of integrity. The words are themselves, as ordinary people understand from ordinary intelligence, must tend to make them look down, shun, or avoid the plaintiff. To prove that the words are defamatory in the natural and ordinary meaning, there is no need for the plaintiff to prove any special knowledge of the people whose word had been published. The labeling of an Islamic man as Abu Jahal is defamatory as it labels the person as a liar, untrustworthy, and irresponsible. Secondly, the word may be defamatory by way of innuendo. Sometimes, defamation does not arise from the literal meaning of the words. Secondly, the word may be defamatory by way of innuendo. Sometimes, defamation does not arise from the literal meanings of the word. Therefore, the word themselves are not defamatory but to be so, based on the conclusion of certain facts or circumstances known to the recipient or the reader of the word. The true or legal innuendo arises due to special facts which are known to the recipient of the publication. This special knowledge will cause the word to be defamatory against the plaintiff. Otherwise, the word is not defamatory. Specific knowledge refers to the special and knowledgeable known or available to those whose words are published. For example, the plaintiff is seen entering the house does not contain any derogatory implications except those who know that the house is a prostitute house. The plaintiff must apply the extrinsic fact that the house is a prostitute house and some people know that it is. He must bring them as a witness to the court and prove that the words of the defendant are conveyed to those who have the above mentioned knowledge, which denies that the plaintiff demands prostitution services.
My name is Naatira binti Muhammad Zuki. In the case of Tolly v. Fry and Sons, stated that the plaintiff is an amateur golf player and the defendant is a chocolate manufacturer. The advertisement is in the newspaper show a caricature playing golf with a defendant chocolate bar attached to the pocket of the pants. In the picture, the whelp is seen pointing to the plaintiff, indicating that the plaintiff's performance is the same as the defendant's chocolate quality. The ad is an advertisement for the defendant's chocolate. The plaintiff claims allegation of defamation. The words and picture were not defamatory before him, but his advice was the plaintiff had received payment for the ad and thus launched his status as an amateur golfer. The Dewan Negara is of the opinion that the defendant is responsible because those who knows the status of the plaintiff made him feel that the plaintiff had agreed and paid the advertisement. Golfers testify that any reputable club can call any amateur golf player who agrees with the advertisement to withdraw its membership, and there is evidence that the defendants know the impact of advertising on the selfish plaintiff's status. In the case of a wrong assassination, the plaintiff does not rely on extrinsic facts to support the meaning of the word defamation, but only specifying a certain conclusion taken from the word itself. The usual conclusion and implication arising from the contained word are also classified as the general meaning and meaning of the words. It is hard to distinguish between false innuendo and the meaning of natural and ordinary words. Perhaps this explains why in many cases the word contained is said to be defamatory either in the natural or ordinary terms or through false innuendo. In Lee Kuan Yew versus J.P. Jeyaretnam, during the election rally for a general election, the defendant spoke of the performance of the plaintiff. Thus, I'm not very good in the management of my own personal fortunes, but Mr. Lee Kuan Yew has managed his personal fortune very well. He is the Prime Minister of Singapore. His wife is the senior partner of Lee and his brother the director of several companies. So Mr. Lee Kuan Yew is very adept in managing his own personal fortunes. But I'm not. If I become Prime Minister, there will be no firm of J.P. Jeyaretnam and Co. in Singapore because I will not know how to manage my own personal fortunes. The court held that in that context, the words in their natural and ordinary meaning implied that the Prime Minister had gained and secured personal financial advantage for himself and his family members from his position. Defamation was established. Thirdly, by way of acute style position usually involve a solution that employs visual effects such as FPT or placing the plaintiff's photograph in a pile of pictures of wanted criminals. Thus, defamatory imputation can arise from material other than written or spoken words. This can be illustrated in the case of Monsoon versus Susabs, stated that the plaintiff was accused of committing a crime in Scotland. The crime was not proven and the plaintiff was released. The defendant then erected the statue of the plaintiff and placed the statue together with statues of other criminals. The court found that the defendant liable for defamation.
3.
In addition, the words must refer to the plaintiff. If the defendant intends and refer to the plaintiff by name, it will certainly meet the above requirements. Although the plaintiff are not specifically named in the words, he may be so recognized. Therefore, if in such a case the description is such that a person who hears or reads the alleged word reasonably believe that the plaintiff is referred to, it shall be sufficient reference to him. It does not require people to understand the words as defamatory against the plaintiff. It is sufficient that those who know the plaintiff believe that he is the person referred. Only the defamatory person can act in defamation. Others cannot act on their behalf.
A person's reputation is said to have died with him on his death, so an heir cannot begin the process on behalf of the deceased. In Houghton and Co. vs. Jones, the defendant were the owners of the press and published in their paper a funny report of the motorcycle festival in France, where implications were placed on the moral of accused Jones, a charge warden at Becker. They meant this person to be and the author of the article, and the paper editor believed it to be simply fictitious. There is a lawyer named Artemis Jones, who is not a church warden, who does not live in Becker and does not participate in the celebrations. He sued the defendant for his libel, and his friends testified that they thought the article was referring to him. The jury replied the decision to the plaintiff. Your home affirmed the decision and states that it is not a defender for the defendant, that he did not intend to defend the plaintiff. The last element is the words that have been published. Publication are the communication of the words to at least one person other than the person being slandered. Where the communication is to the plaintiff himself, there is no publication because defamation is an injury to one person's reputation, not his own opinion, and reputation is the opinion of another person about a man and not his own opinion. Therefore, if the word or printed material is not heard or seen by a third party, and only the plaintiff who hear or see it, the publication does not arise. As stated in the case of Wan Abdul Rashid versus Siwa Subramaniam, saying that the defendant was an advocate and solicitor who denied the plaintiff, the session court registrar in Kuantan as a corrupt person before the court staff and the public. The court held that there is publication as a word spoken in society. On the other hand, in Hart versus Hart, where a butler with a defamation letter written by the defendant's husband who is plaintiff wife is in an unsure England. The court is of the view that there is no publication as it cannot reasonably expect it to be in the circumstances that the letter addressed to the wife is likely to be opened and read by the butler. The publication was unpredictable. For the causes, online defamation occurs frequently because people nowadays choose to use internet more often because it is used worldwide, and it is cheaper in cost compared to any other type of communication device. Since this medium is used all around the world, the user think that they can use it to voice and their heart and opinion, but some of them misuse by spreading false statements to defend one party and to make their reputation fall. Online defamation also happens because there is no awareness among our society about the effect of it against individual and organization. People nowadays always do or write something without thinking about the consequences of their act until it is too late because there were lack of rationality and maturity in their thinking. Slander is prohibited even in every religion has stated that defamation is an illegal act and it is sinful if done. When there is no such awareness among the society, then there will be defamation act only done every day because they have lost their manners and good values in them. Next, there were many cases of online defamation because the law on cyber cases is still weak. Meanwhile, places that frequently used to spread the slander were blogs and communication apps such as WhatsApp and Facebook, which is websites that were used the most by internet, used to spread useful information and sometimes were misused for online defamation. And there is no specific law that can be used against these activities, making the people who were responsible for the defamation felt safe and thinking that they can do it more often.
My name is Najah Netizen TV, and there is an effect under the online defamation. One of the effects of online people towards people is that it will humiliate someone's name and reputation. This effect can make the society feel hatred and hostility toward the victim. When this thing happens, the victim will not only receive hatred, but his credibility and reputation will be questioned by people around him. Once this thing happens to the victim, then their earnings such as occupation would be affected too. Secondly, online defamation would cause effect in way of disturbance on the victim's mental health. When a normal people involved in online defamation as the victim, that person usually felt stressed and can lead to depression because of the hatred and that they receive by the surrounding. If the victim does not have a strong mental and good faith, they would feel down until one situation where they felt scared to face the society and choose to stay in their room and to avoid any hatred towards them. Other than that, online defamation also can lower the country's reputation when there is misunderstanding caused by the online defamation. The country would face many consequences such as racist issue and even threatens the country's safety. It is because this misunderstanding would cause anti-country sentiment by other countries because of the negative perspective. Lastly, because of the negative perception caused by this online defamation, our country would lose their investors because they lost their trust and confidence to invest in our country. This situation would cause economic problem to our country, and it would be hard for us as the citizens of this country to live in this economic downturn era. And how to prevent this online defamation? In the era of society, there is always growing development that the mass media plays an important role in realizing truths towards a more modern life. The ability of the internet as a means of communication for exceeds conventional communication tools. Facebook is one of the latest inventions in the information technology industry. It also brings disadvantages if misused. The irresponsible person uses Facebook to send false and wrong information and distribute it to other users. If the defamatory party cannot accept the spread of the defamation imposed on them, there must be a serious misunderstanding and serious confession. More dangerous, there are also causes that Facebook is abused to host certain groups such as children and adolescents. Various laws in Malaysia can be enforced to regulate what is happening in cyberspace, including Facebook, like the Communications and Multimedia Act 1998, Act 588, Criminal Computer Act 1997, Act 563, Sedition Act 1948, 15, Pollution Act 1957, Act 286, and the Penal Code Act 574. The cases involving internet abuse, including Facebook, may be reduced by ongoing law enforcement. As a measure of internet usage, the government has also made amendments to the Evidence Act 1950, Act 56, which includes legal procedures to prove internet crimes, including Facebook. This amendment was approved at the House of Representatives on 8th April 2012 and came into force on 31st July 2012. The amendment of Act 56 was made with the addition of Section 114A titled Statement of Impressions in Publication. Section 114A may be used in both criminal and civil cases. If the owner, operator, host, editor, network client or website, or the owner of the computer or mobile device is considered as responsible or repeat the content of the network, the web or related equipment. The main purpose of this amendment is to identify individuals responsible for the broadcasting and dissemination of such materials on the internet. Given the fact that Facebook account change is still widespread, it is up to the government to study proposals for releasing every registered Facebook socialite user. For some individuals, the proposal is unlikely to be done by the large number of users, but it should be noted that almost the same measure was taken by the government in 2006 when it jeopardized the registration of prepaid mobile phone users to help authorities track those who use the service to make calls or defamatory service or cheap short messages. Apart from that, the Communications and Multimedia Commission (MCMC) needs to be strengthened, and if not enough staff to monitor 18 million internet users, the government needs to increase the workplace. Existing laws need to be reviewed. For example, in the current law, the MCMC cannot restrain the person from wrong because of his true duty to investigate in the form of internet forensics. Police are authorized to detain, and the Attorney General's office is liable to prosecute. It is time to end. MCMC is authorized to investigate, detain, and prosecute all forms of error in cyberspace in view of the rapid development of the technology world. Let the police and the Attorney General office be outside cyberspace, which is also challenging now. This can help ease the burden of police. Not to mention the criminal case that day, the punishment also need to be heavier. Penalties pursuant to the Communications and Multimedia Act 1998 are only a maximum fine of 50,000 ringgit or imprisonment not more than 1 year or both. We accept the reality of progress in cyberspace, and nothing can block anyone to express or post anything on social sites, but abuse can invite disaster. To curb this abuse, there must be a legal form of control. Anything else, more importantly, is that there should be self-filtering by knowing what to upload or otherwise.
Assalamualaikum warahmatullahi wabarakatuh. My name is Salma Farisi. For the cases for this topic, in the Bhopal case, tragedy case, 470 million compensation Defamation was awarded by the Supreme Court on February 15, when, as the official estimate number of people who died was 3,000 at the time. Compare it with 100 rupees crore awarded for defamation caused by the wrong display of photograph for 50 seconds, and for which apology was being tendered. The life of common man is worth much less compared to the dignity of a former judge, when it is not even certain that the reputation was damaged. Besides, the speed with which the case has been decided also speaks volumes about our legal process. Someone has filed the suit on November 13, 2008, and on April 26, 2011, the court delivered its judgment, awarding 100 rupees crore to the plaintiff. Countless defamation cases are pending for decades, and the aggrieved parties get only next dates. As Nabi Narayanan, then head the Indian Special Research Organisation (ISRO), was falsely implicated in an espionage case. The other cases that can be related in this situation is the case of Elias Hertford and Flower versus Rolling Stone case. The ongoing variant caused by the 2014 article a rape on campus and subsequent podcast, which alleged that a student was raped by members of the University of PKC, come to a head over this year. This case concerns 3 members of the fraternity who brought defamation lawsuit against the magazine, separate from the previous cases brought by the fraternity itself and an associate dean of the university. In September 2017, the U.S. Court of Appeals for the Second Circuit reversed the district court's dismissal of the case regarding plaintiffs Elias and Fowler, holding that information provided in the article was sufficient to identify them personally. For the last case in the communication apps such as WhatsApp and Facebook, which is a site that were used the most by internet users, is in the case of Ummi Hafid Ali and another versus Karangcraft Sejahtera and others. The defendant has been sued by the plaintiff for publishing an article about them in Bakaria. Both plaintiffs played a key role as witnesses in the corruption trial against the former Deputy Prime Minister of Malaysia. The article was untrue and false, and thus the plaintiff has defamed them. Both plaintiffs claim a sum 10 million ringgit as general and compensatory damages and for exemplary damage. The defendants submitted that the repugnant passage in the article was picked up from the internet news, and that by reporting such news, the defendant had in fact shown the falsity of such news. Further, it was submitted that whilst the headline read The court could The court could not agree to the defendant's explanation that the letter by the defendant's solicitor's firm addressed to the plaintiff's legal company was to seek the clarification. There was no request for clarification, nor because there was any subject matter that needed to be clarified. The contents consisted of derogatory remarks which had no truth in them. They implied the plaintiff was a person of low morals, lustful and mean, and for this has exposed him to hatred, contempt and ridicule by the right-thinking members of society. Though the publication of the letter was to the plaintiff's staff, the defendant was considered liable by defamation when such publication was to the plaintiff's servant or agent. By Section 5 and Section 6 of Defamation Act 1957, in a slander to the plaintiff, there should be no necessity for the plaintiff to prove that he has suffered damage. Regarding the cases of Prime Minister Su's website for libel, which is Malaysia's Najib Razak, made history by becoming the country's first Prime Minister to sue a media organization by libel. The case, however, is rather odd since Najib's lawyers are claiming that he was defamed by the comments made by readers of the Malaysian Kini News website. In other words, Najib is suing Malaysian Kini editors not for publishing a libelous news story, but for allowing libelous comments to be posted on their website. Further, it was submitted that once the headline read Umi Hafil dan Nikah, yet the final passage on the same front page quote the first plaintiff's brother as denying that the first and second plaintiffs were married. Therefore, it was urged to apply the bulk of the brother's denial to soothe the vein of the headline. The court held that the defendant's failure to produce the printed internet webpage must be held against them. Their failure to produce the journalist's note as the source of the article must also be held against them. The journalist does not make any effort to ascertain the truth or otherwise from the plaintiff themselves. In any case, even if there was a republication of the internet page, is publication of defamatory statement. A libel action brought in the case of Gill versus Anagnos. For the conclusion, defamation and threats to defamation are often used to try to silence those who criticize the people with money and power. The laws and legal system need to be changed, but at the same time, recognizing your rights and observing some simple guidelines can help you make informed choice about what to say and publish.